All right, good morning, everyone. I'm Judge Jackie Powell, and we are in first appearance court. Today, I'm going to let you know if I've determined probable cause, and then we will talk about release conditions. Please note that today's not your trial date, so I advise you not to talk about your case on the record because everything in this courtroom is being recorded. If you are represented by the attorneys from the Public Defender's Office, you may speak with those attorneys before saying anything on the record. I do have one attorney in the courtroom with me and another attorney over at the main jail. For those of you who are represented by the private counsel, they normally come to the courtroom and will be able to speak on your behalf. If you have counsel and your attorney's not here, you can let us know and we will see how we can accommodate you in that process. Please don't tell us that you have private attorney if you have not retained them for this recent arrest. Just because an attorney represented you 2 years ago or a month ago does not necessarily mean that they're representing you here. So unless you or your family have retained them, please, we do this every day and sometimes we call and only to be told that the attorneys are not representing you on this case. Please note that in the courtroom, we also have the state attorney's office representing representing the state, as well as confinement status, pretrial supervision, and we do have the clerk of court to maintain records. All right, so when I call your name, I'm going to ask you to step up to the podium, then we'll be able to address each person individually. On page 20, the jail is asked
Mr.
to
Joseph?
call Mr. Joseph out of turn, so Antoine Joseph,
Peace here, President Judge Amain, approaching. Good morning.
good morning. So, Mr. Joseph, you are before the court this morning for one count of possession of cocaine. Count two is possession of cannabis 20 grams or less. Count three is resisting officer without violence, and the court does find probable cause.
Judge, and speaking to Mr. Joseph earlier today, I did inform him as far as the $1,000 bond. From what he informed me, his mom's not in a financial position to post his bond. We're going to be request the court consider releasing Mr. Joseph on standard pretrial release. Considering this is drug offense, we wouldn't be objecting if the court also wanted to impose random drug testing. Now, Mr. Joseph has been living here in our community almost his whole entire life. He's 34 years old. He lives in Lauderhill with his mother. Right now, he tells me he's looking for employment but hasn't had much success. Considering this is a nonviolent offense, we're asking for the court to consider releasing Mr. Joseph on pretrial release.
One moment, Judge.
Sure.
Thank you. Let me know what stuff he gets out of county. Your Honor, the state would be opposing pretrial release out of Broward. Mr. Joseph has a 2018 resisting without violence, '09 possession of firearm by convicted felon, 3 years state prison as a habitual offender, resisting without violence, delivery of cocaine '05, 34 and a half months state prison, possession of cocaine '04, 34 and a half months state prison, '05 possession of cannabis with intent to sell, just under 35 months state prison. Additionally,
Judge, from what I heard, I believe the last time he had, even though he has a bad record, the last time he had contact was June of last year. It's been almost a year, Judge. I'm asking if the court would, on this drug offense, consider releasing him.
one moment, Your Honor, wasn't done. He had out-of-county stuff in 2017, just recently. I'm showing he was picked up in 2018 in Palm Beach on a conditional release violation. In Palm Beach. One moment, Judge. 2017, grand theft, unauthorized use or possession of an identification of another, fraudulent use of a credit card, burglary of a structure, grand theft, unauthorized use of a ID of another. I'm showing Mr. Joseph has 12 prior felony convictions.
Okay, reviewing this probable cause affidavit, Mr. Joseph, the allegations are that the officers were not able to detain him without using a taser as he was running from the police. As at this time, the court does find probable cause, and I will leave the bond of $1,000 in place. All right,
Judge, would you sign a photo order?
sure. Nicole Johnson,
No problem, Your Honor. Good morning.
and just so private counsel know, depending on where your client is on so if you'll let us know where they are, if they already signed in, so that we can advise the jail, okay? All right, Nicole Johnson, is that,
North Broward.
all right, Ms. Johnson is before the court for one count of aggravated battery. It's domestic, and the court does find probable cause. Hear from the parties as the bond.
Judge, I did speak to Ms. Johnson. I don't believe she has significant priors. I think there was just a misdemeanor trespass that I'm aware of. She's a lifelong resident of Broward County. My understanding is the victim does not reside with them. The only income she has is a disability. So her funds are limited. She does not have any money in the bank at this time. I'm sorry I didn't get to speak to the gentleman who's here yet. I didn't know. he
Good
was
morning,
here.
sir. Oh,
Kevin Scott, and
Oh.
I'm a longtime friend of Nicole.
okay,
We've been knowing each other. Out of these 20 years, we never had any problems. She got a son that is in college, one son, and I just wanted to say that I don't want to press charges because we never had any problem. It just was a time that we were celebrating the holiday and went to a party, and too much alcohol was consumed, and things got out of the hand, which never occurred before, except this time. So it's not a problem, and she is not a threat, because it's been too long. We've been together, and as friends, and she's not, a violent person to me, period,
okay.
Court can consider releasing her on standard pretrial.
Your Honor, the state's going to be seeking a $5,000 bond noting the allegation, and this was confirmed with multiple witnesses. That Ms. Johnson, using a broken bottle, cut the victim, also punching him in the face. I would note Ms. Johnson was arrested in 2016 for domestic violence, aggravated assault, a deadly weapon against a different alleged victim when she allegedly threatened the victim with a kitchen knife, threatened to stab the victim, and ended up punching that victim 3 times in the face. Those charges ended up being dropped. Ms. Johnson had a trespass in 2016, a theft in 2012, and she was arrested in 2004 for domestic violence battery against a different alleged victim. That charge was dropped as well.
She advised me at this point she doesn't have any money in the bank, but could potentially afford $100 if Your Honor would set it at $1,000.
Plus years. And it's the first time that we ever had a problem. And the reason that was because it was too much alcohol consumed at this particular time.
Okay, what's your last name, sir?
Scott,
All right, Mr. Scott, there is normally a no contact order that's issued in these matters. And no contact would mean that, if Ms. Johnson, you and Ms. Johnson live together, that you wouldn't be able to, be in the home until, there's further finding. So what are you saying today?
Saying that, right now, me and Miss Johnson do not live together.
Oh, you don't live together?
No, ma'am.
All right, all right, so the court finds probable cause. I am going to release Ms. Johnson to pretrial supervision and no contact until further order of the court. Okay? All right, good luck, ma'am.
Thank you.
All right, Mr. Romero?
Yes, Judge.
Can you tell me up to what page you?
We're up to 17, Judge.
So up to page 17 is in the room?
Yes, ma'am.
Okay, all right, so on page 28, there's Cedric Cruz. There's a private attorney that's here, is not
I'll
in the
let the
room yet.
deputies know.
I'm letting the deputies know so that they can bring him in. Also on page,
Private attorney's here. Okay?
on page,
Yes, Judge.
on page 21,
Yes, ma'am.
Eric McKinney.
And on page 21, Mr. McKinney. 21. Yes, Judge.
And
Anybody
then
else?
just one more on page 23, Reyes.
Reyes, private.
Okay?
And on page 23, Reyes.
All right, if you'll just, when they're there, let me know, okay?
I will. Thank you.
Thank you. All right, on page, 1, let's go back to 1, Victor, Marley Victor.
Ms. Victor's here present. Just come on up, Ms. Victor.
All right, Ms. Victor is before the court this morning for aggravated battery, where the alleged victim is pregnant. The court does find probable cause. I'll hear from the parties, Esteban.
Your Honor, the state would be requesting a $2,500 bond and no victim contact.
And does Ms. Victor have any priors?
No, Judge.
Okay.
Judge, in speaking with Mrs. Victor, she appreciates the fact that her husband and friends are here present. She believes she's going to be counting on her husband to post her bond. She believes that's going to be possible. So at this time, nothing to add by the defense, Judge.
Okay.
There's
Well,
also an explanation given for that in the report, Your Honor.
all right, at this point in time, I will impose a $2,500 bond, and I'm gonna say no victim contact until further order of the court, okay?
Thank you.
All right?
What's that? I'll show you. Last paragraph.
All right, on page 17, Javoris Green.
Mr. Green, come on up, please. Your private attorney, come this way. Your private attorney's here present. He's approaching, Judge.
There's
Oh,
not a private, I guess, family or somebody said.
Oh, family. No, it's family, not private.
Have you had an opportunity to speak with him? Okay.
Yes.
All right, Mr. Green is before the court this morning for battery on an officer or firefighter. The court does find probable cause. We'll hear from the parties as to bond.
Guys. Michelle, do you have anything? State would be requesting a $2,000 bond, Your Honor.
Okay. And does Mr. Green have any priors?
None that I see.
Okay.
Judge, considering the circumstances, normally I would say that's reasonable. But in speaking with Mr. Green earlier today, and it still doesn't change, he financially can't afford to post a monetary bond. He's been living in our community his whole entire life. He advised me he's looking for work. He lives here in Broward County locally in Deerfield Beach. What we're asking for Mr. Green is for the court to either consider releasing him ROR or in the alternative under supervision with pretrial release, Judge.
Considering the allegation that he spit in an officer's face, I think the $2,000 bond request is reasonable.
Judge, I would just like to point out, and I'm reading the police report, as the state just said, he didn't make contact with his face. It said made contact with my uniform. Left arm and side.
And
It seems like a,
left side of my face.
Okay, good morning, sir.
Good morning, ma'am.
What is your name?
Stanley Green.
Mr. Green, is there something you wish to say to the court?
I'll try to get him out of jail. I'll see what was really going on.
Okay.
He's not a bad kid. He just going to college, stuff like that.
He's going to, where does he go to college?
And TCC, last time I spoke with him.
Okay.
And Judge, he just wanted to say he appreciates his father being here for him.
All right, I am going to impose a $2,000 bond at this time, okay?
Okay.
All right. All right, thank you, sir.
Judge, I believe that the people that you were waiting on are here now on page 21. Mr. McKinney.
Okay,
McKinney, come on up. Your private attorney, Mr. Coffey, is there. Right.
all right. Eric McKinney? All right, Mr. McKinney, you are before the court this morning. Count one is burglary, unoccupied conveyance unarmed. Count two is illegal use of credit card, and count three is grand theft.
Do you press their heart? Do you work? What'd you think?
All right, the court does find probable cause.
Good morning, Andy Coffey on behalf of Mr. McKinney. I spoke to Mr. Linder already. Judge, we've agreed to a $5,000 bond in total. So however that needs to be broken down.
3,000 on one, and then the standard bonds on the other two.
All right.
And just in order of no victim contact. Jeez, what is
There's a lot, did you say no victim contact?
Yes,
Oh,
trying to get it over there.
All right,
With, Jeffrey Grinnell, sorry.
Jeffrey Grinnell
Yes,
is
ma'am.
the, okay, all right. So as to count one, I'll impose a $3,000 bond. Counts two and three of $1,000 each, giving you a total of $5,000. And then no victim contact. Do you understand that, sir?
Yes.
All right, sir, good luck.
Thank you, Judge.
Good luck, sir.
Judge, and on page 23, Mr. Reyes is here present, Judge.
All right, but Mr. Cruz is not there yet?
On page 28?
Yeah.
Let me see. 20, he's here. Mr. Cruz?
All right,
Come on up, your private attorney's here
let me
present.
address Mr. Cruz first.
Come on up, Mr. Cruz.
Good morning.
Your private attorney. Right there in the bottom, okay?
All right, so Cedric Cruz is before the court this morning. Count one is possession of cannabis over 20 grams. Count two is resisting officer without violence. Count three is disobeying a traffic light.
Yes, sir.
Good morning. The court does find probable cause. Good morning, Mr. Dobrinsky.
Yes, sir. Stefan Obrinsky on behalf of Mr. Cruz.
All right, I'll hear from the parties as to bond.
Your Honor, the state would request $1,000 bond on count two.
Okay.
Your Honor, during the probable cause affidavit, I think there's certainly probable cause for resisting without violence. But I don't know that it's specific enough for with violence. While they say that there was pushing, pulling, and kicking, it doesn't even mention which officer was the victim of this resisting with violence. So I'm asking that the court find probable cause for resisting without and place a $100 bond.
Your Honor, it specifically states in the last sentence of page 2, going into 3, the defendant actively and physically resisted the officer's attempts to place him into my patrol vehicle by using his elbows and feet. I don't believe it needs to specifically state which officer. It is clear that it was during the process, during the attempt to arrest him, so certainly it was against an officer.
But I do believe they need to prove as an element what specifically which officer was the victim of this.
Well, that would be for another day. For probable cause, there is a finding for probable cause. So as to bond, the state asked for $1,000 on count two.
No objection to $1,000 bond.
All right, so I'll impose $1,000 bond on count two. So he has a total of $2,000 bond. Okay?
Thank you, Judge.
All right. All right, on page 7, Billy Santisteban, is he there today?
North Broward.
Okay. It's a she, I'm sorry. All right. All right, good morning, ma'am. You are before the court today for count one is possession of heroin. And count two is a misdemeanor capias, which is a municipal ordinance violation. The court does find probable cause.
What's your history like?
Checking it right now.
And I'll hear from the parties as to bond. I know that you have a municipal ordinance violation.
I'm
Do you
just checking
want
to see what her history is, Judge. If it's not that bad, she can resolve it. Judge, we ask that it be sent to the division.
Okay. All right, so she's $1,000 bond on count one, and then $250 on the capias on count two, okay? All right, good luck, ma'am. George Yordi on page 12.
I'm sorry, I'm Santos.
I'm sorry?
With regards to, we just did Santisteban.
Yes.
Judge, I did have an opportunity to speak to her. As far as the $1,000 bond goes, I was gonna ask the court to consider a lower bond. I spoke to her, she cannot afford that. She's living with a boyfriend, she doesn't have any money in the bank, and is not working. And then looking at the police report, it looks more along the lines of a paraphernalia. There was an allegation involving a pipe and a syringe, noting in the police report that the pipe was broken on scene, and pieces were not recoverable. At this point, I know she can't afford that $1,000 bond, Your Honor. I'd ask the court to consider releasing her to pretrial.
Ms. Santisteban is out right now in a burglary of a conveyance.
I'm sorry?
She's out right now in a pending burglary conveyance.
And I've been
All
appearing
right,
to
ma'am,
court.
ma'am, don't talk about your
discuss your
case,
case, okay.
all right? So her bond is $1,000, okay? George Yordi on page 12.
I can't afford that.
She's done. You already did medical research on it.
Okay, thank you.
Was it already medical research? You already?
And then Jesse Adams on page 14.
He's approaching, Judge.
Okay.
Come on up.
All right, Mr. Adams, you're before the court on a municipal ordinance violation. The court does find probable cause. What does Mr. Adams wish to do?
Judge, the city would offer time served on this matter. We'd like to resolve it.
Mr. Adams, would you like to resolve your case today?
Yes, ma'am.
And do you heard the offer is adjudication and time served?
I'm sorry, I can't hear you. There's a lot going on here.
All right, the offer to resolve your case is adjudication and time served.
Yes, ma'am.
Do you wish to accept that, Mr. Adams?
Yes.
All right, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Mr. Adams, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with the attorney?
No.
And sir, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right.
There was a lot going on here. I can't hear you. I'm sorry.
You have the right to go to trial. By taking a plea today, you are giving up that right. Do you understand that?
Yes.
All right, and have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I understand. I'm a citizen.
What plea do you wish to enter, sir? You have two choices. It's guilty or no contest, okay? So accept your no contest plea, find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir. And then on page 23, Joseph Reyes.
Joseph Reyes?
All right, Mr. Reyes, you have two misdemeanor capias. Counts 1 and 2 are a misdemeanor capias on a municipal ordinance violation. Counts 3 and 4 are felony violation of probations, and those are no bond holds. And so you have court the 29th, that's tomorrow, and then on the 30th on the misdemeanor actions, okay? All
Thank you,
right,
Judge.
good luck, sir.
Thank you, Judge.
All right.
Sure.
All right. Okay. Jacqueline Moratz. All right, good morning, ma'am. You are before the court for count 1 is touch or strike battery, and count 2 is tampering in a misdemeanor proceeding. The court does find probable cause. I'll hear as to bond.
Your Honor, the state is requesting a $2,500 bond on each count in order of no victim contact. I am concerned that Ms. Moratz would follow a no contact order from this court, seeing that she is currently on probation in front of Judge Malika for violation of an injunction. She was placed on a year's probation September 14th of last year. And that's against a different alleged victim. She was arrested last year also for aggravated stalking, violating an injunction, and another count of violation of injunction that was dropped. Battery, last year that was dropped. A battery arrest in '07 that was dropped. In '05, she was convicted of grand theft, 2 counts of felony battery due to priors, possession of alprazolam and hydrocodone, and assault. Possession of cocaine '03, possession of alprazolam '02, cocaine '01. Nothing further as far as Broward, Your Honor.
All right, finding probable cause, I am going to impose $2,500 on each count and no victim contact until further order of the court. Ma'am, do you understand that?
Yes.
All right, it means no phone calls, no text messages, no third-party attempt to get in touch with the victim, okay?
Okay.
All right, good luck. All right, Samantha Steers,
Medical reset.
okay? How about Patricia Kern?
Judge, she's here present at Maine.
All right, Ms. Kern is before the court for possession of controlled substance without prescription. And the court does find probable cause. I just have one question. Throughout the report, it refers to the Patricia Helhosky.
I believe that's her married name, and Kern is her maiden name, Judge.
All right, I just wanted to make sure. Okay, so finding probable cause, I'll hear from the parties as to bond.
Judge, seeing Miss Kern, unfortunately, she's homeless at this time. She's 59 years old. Considering this is a non-violent offense, I'm asking the court if the court will consider an ROR or in the alternative to release Miss Kern on pretrial release.
Okay.
I'd have no objection to pretrial, Your Honor.
All right, does Ms. Kern have any priors?
She does, she has some throughout Florida. One moment, Judge. Theft out of St. Lucie from a few years ago. She has dated priors out of the state of New York.
All right, I'll release Ms. Kern to pretrial supervision, okay?
Thank you.
Ma'am, the attorney's handing you the instructions and the address. You must report within 24 hours of your release. Failure to report will result in a warrant being issued for your arrest, okay?
Yes.
Good luck, ma'am.
All right, Ayana Akri,
No problem, Your Honor.
all right, Ms. Akri, you are before the court today for 1 count of grand theft, and the court does find probable cause. And I'll hear from the attorneys as to bond.
I'm not aware of any priors with regards to Miss Akri. I do know that she has family local and that she has her husband and her aunt. They're currently living with a friend. It's my understanding that she does not have money in the bank at this time. I'd ask the court to consider standard pretrial.
Your Honor, my concern, I wouldn't have a problem pretrial if they verify residence, but I'm showing a Georgia address. She has domestic violence battery out of Georgia. There was another arrest in February of last year, and from what I can tell, it's still pending in the state of Georgia. That was for domestic violence battery as well.
Okay, ma'am, are you residing in Florida?
Yes, ma'am, I am.
And
I've been working out here. I'm trying to. My kids are
where are
current.
you working?
I work for Glass Replacements LLC. It's a windshield company. We go around, we knock on doors, and we get windshields installed through the insurance, ma'am.
How long have you been working for them?
I've been working for probably about 2 months. I came down to Fort Lauderdale because it was more opportunity here for me. So that's where I'm from. My mom lives. My ID is out of Georgia because I just moved down here. But I plan on staying here in Florida because it's more opportunity for business for me.
And who do you live with down here?
I currently live with my friend. And we basically after I move out with my friend, I'm definitely gonna probably get my own apartment here in the next couple weeks. I'm just working towards it right now. I made a decision, and I apologize.
All right, don't talk about the case. I am going to release you to pretrial supervision. The deputy is going to give you the address and the directions. Ma'am, if you don't report, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right, good luck.
Thank you.
Retha Jones,
Approaching Judge here at Maine. Come on up, ma'am.
all right. So Ms. Jones is before the court for one count of criminal mischief. The court does find probable cause, and I've been advised that Ms. Jones's bond has been posted. All right, Jessica Pinero, she here today?
I believe North Broward.
All right. Ms. Pinero is before the court. Count 1 is possession of cocaine. Count 2 is possession of alprazolam. Count 3 is selling heroin. And the court does find probable cause. And we'll hear from the parties as to bond.
She has resided in Broward County since the age of 4, has a job in the insurance business, currently is renting a home. She does have family local. The issue that she was having, I know, is there's the Nebia and collateral requirement, which is giving her an issue, and also in terms of the passport, that she does not actually have a passport to surrender. She does have 5 children, and she's living with her fiance, actually 4 stepchildren, 1 child of her own local, and is not a flight risk at this time. I'm not sure if the state is asking for any increase in the bond. I think the issue is a $25,000 bond. I'd ask the court to consider if we could reduce that.
Your Honor, I actually spoke with Detective Kastner last week.
Okay?
The state has no objection to waiving the special conditions except for that she shall not be in possession of any firearms. Frankly, and I discussed with Detective Kastner, based on his investigation, he does believe she can post a $25,000 bond. And from his conversations with her, he did not get any indication that there'd be an issue posting it. Obviously, the Nebia would stand in the way of that.
Right, Judge, that was the main issue, is if we would be able to waive the Nebia and the collateral, and the passport.
All right, so finding probable cause, the bonds will remain in place, and I will waive the Nebia and the passport. Do we agree to the passport?
That can be waived too.
Okay,
And the collateral.
Just let her know. Yeah, okay, that's fine.
and the collateral, okay? No firearms or weapons, do you understand that? Okay.
Yes, Your Honor.
All right, good luck. All right, Taryn Robinson.
Mr. Robinson is here at main, Judge, approaching. Come on up, sir.
All right, Mr. Robinson, you are before the court for one count of burglary with assault or battery. Count two is touch or strike battery, domestic violence, and count three is tampering in a first-degree felony proceeding. The court does find probable cause.
Your Honor, the state would be seeking a no bond hold on count one upon the finding of proof evident or presumption great for first appearance purposes only, relying upon the probable cause affidavit. Also, for consideration for the court in exercising your discretion or not, Mr. Robinson in 2006 was convicted of burglary of a dwelling and grand theft. He was sentenced to 8 years state prison on a youthful offender sentence.
I would just ask the court not to make a finding as to proof evident presumption great, based on a police report for probable cause purposes. It's basically a paragraph long. There's no witness statements or affidavits attached, being that proof evident presumption great is the highest standard that we have, which is beyond a reasonable doubt. Actually, more than that. I'd ask the court not to make a finding of proof evident presumption great at this time.
All right, based on the probable cause affidavit that's before the court this morning, I will not make a finding of proof evident presumption great. So as to bond,
Your Honor, the state would be requesting a $25,000 bond on count one, a $2,500 bond on two, a $5,000 bond on count three. Your Honor, based on these allegations, Mr. Robinson used their children in common as a means to not only get access physically to the victim, but then to attack her, and then destroying her cell phone to prevent her from calling 911.
okay?
Judge, I apologize. On count one and count two, what was the state asking for as far as a monetary bond?
25,000 and 2,500.
Judge, in speaking with Mr. Robinson, he's not in a financial position to post that sort of bond, nor is his girlfriend is. Now, he does not live with the alleged victim. They do have children in common, and I was telling him as far as what the state talked about some of the facts, and he's taking issue with some of the facts, but I did advise him he will have his day in court in the future to fight those allegations. Having said that, Judge, right now he's working. He works at an auto body facility where he makes approximately $500 per week. He's been here his whole entire life. He lives apart. He lives in Hollywood with his girlfriend, and their monthly rent is approximately $1,100. Now, that's the person he's going to be reaching out to help post his monetary bond. She works at a restaurant, Judge. So between him and his girlfriend, their funds are very limited. I'm going to be asking for the court to consider a $5,000 bond on count one, a $1,000 bond on count two, and a $2,500 bond on count three, Judge. That's what the defense is asking for at this time.
All right, that's to count one. I am imposing $25,000, 2,500 on two, and 5,000 on three. Okay? And no victim contact. Troy Everett.
Come on, Mr. Everett. You're present, Judge.
All right, Mr. Everett is before the court for count one is domestic battery by strangulation, and count two is a felony violation of probation, which has a no bond hold. The court does find probable cause. Here is the bond on count one.
Judge, considering he has a no bond hold, he drives a forklift for a living, makes only $15 an hour. So Judge, I'm gonna ask you to take his financial resource into consideration in determining reasonable bond on count one.
I'm requesting a $10,000 bond, no victim contact. Considering this occurred while he was on probation, and the allegations are that he strangled the victim until she almost lost consciousness.
All right, count one, $10,000, no victim contact. Sir, that means no phone calls, no text message, no social media, no third party on your behalf in contact with her. Do you understand that, sir?
Yes.
Okay, good luck.
On what?
Christopher Curver.
case?
Mr. Carver, come on up, please. He's approaching, Judge.
Which case you don't like?
All right, Mr. Curver is before the court. Count one is aggravated battery causing bodily harm. Count two is touch or strike battery domestic. Count three is domestic battery by strangulation. Count four, false imprisonment. Count five is an out-of-state felony hold. That is out of the state of Pennsylvania. And count six is grand theft. The out-of-state hold is a no bond hold, and you should be going before the extradition court shortly. The court does find probable cause, and I'll hear as to bond on the other counts.
Your Honor, I know he has a no bond hold out of state, but this is a heightened level of violence. Also noting that he's wanted out of state, out of Pennsylvania on a violent matter. I'm requesting a $20,000 bond on count one, a $2,500 bond on count two, a $10,000 bond on count three, and a $2,500 bond on count four. Should he be eligible for release from Broward, at some point, I'd be requesting pretrial release with a GPS monitor and no victim contact.
And aside from the Pennsylvania matter, are there any other priors?
I don't have him in my system. I'd have to refer to rely on pretrial.
Okay.
And Judge, while they're looking at that, he's 23 years old, here for 2 years now, living in our community. He works for a company that specializes in flooring and construction, where he's been employed there for 1.5 years, making about $13 an hour. I do realize he has an out-of-state hold. So at this time, Judge, I'm gonna be asking you to take his, what he gets paid hourly into consideration, determining reasonable release conditions for Mr. Kerber.
All right, the allegations in this probable cause affidavit does give rise to concern. The alleged victim received a laceration from a knife, that she was bitten. There was teeth marks on her right shoulder. And then further allegations are that the key fob, someone tried to take her to the hospital. The key fob was taken, so they couldn't drive. Further allegations that she was strangled. Based on those allegations, the court does find probable cause. Count one, I am going to impose a $20,000 bond. Count two, $2,500. Count three, $10,000. And count four, $2,500. Count five is a no bond hold, and count six has a $1,000 bond, and that's going to include a level 2 GPS. Okay? And no victim contact, in case I didn't say that before, okay? Edward Ramirez.
Judge, Mr. Ramirez is approaching, and he declined the services of public defender.
Mr. Ramirez, you're before the court this morning, sir. Count one is touch or strike battery. Counts 2, 3, and 4 are felony violation of probations with no bond holds. The court will find probable cause. You have court tomorrow in your felony division, and does anyone wish to be heard as to the bond on one?
Your Honor, based on the allegations, the state would be requesting a $5,000 bond and no victim contact.
All right, Mr. Ramirez, first I'm gonna tell you that you can have no contact with the alleged victim in this case until further order of the court. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, ma'am. What about my clothing and all that?
Well, is this where you live?
Yeah, she's my wife.
Well, then you can go one time with law enforcement to pick up your stuff, okay?
Okay.
And your bond is $5,000. Good luck, sir.
Thank you.
All right, do we have Kimani Pierce today?
No, he's still on loan, Your Honor.
Still on loan? All right, Philip Patnell?
He's approaching, Judge, he's here at me.
All right, sir, you are before the court for count one is touch or strike battery. Count two is a felony violation of probation, which has a no bond hold. The court does find probable cause. And I'll hear as to bond.
State would
Judge,
request,
oh, I'm sorry.
that's right, state would request $2,500 bond, no victim contact.
Okay,
Judge, considering he's being held no bond, all we're gonna be requesting is a photo order.
all right, I'll sign that photo order. The bond on count one is $2,500. And sir, no victim contact until further order of the court. Okay? Hunter Holmesy?
Come on up, sir.
All right, Mr. Holmesy is before the court for one count of aggravated battery on a pregnant victim. Count two is a violation of misdemeanor probation. That has a $500 bond attached to it. The court finds probable cause. And here is the bond.
One moment, Judge. Your Honor, I'd be requesting a $10,000 bond, no victim contact on count one. This is now the third time since 2017 that Mr. Homsey's been arrested for battery against Ms. Volin Agers. He was arrested 2018 for domestic violence battery, that was dropped. Again in 2017 for domestic violence battery, that was dropped.
Judge, I'm gonna be requesting a $5,000 bond. Right now, Mr. Holmesy is both currently working and going to school. He goes to McFadder Tech, where he's studying welding. He's been doing that and going to school Monday through Friday from 8 a.m. to 30 p.m. He's also working. He works at a restaurant called the Broadwalk, where he's a cook, making about $13 an hour, and he just got that job about 3 months ago. He will be abiding by order as far as no contact. He'll be finding a separate place to live, separate and apart from the alleged victim. He has a family that live in our community, specifically his grandfather that he's going to be reaching out to help post a monetary bond. From his understanding, grandfather is elderly and on a fixed income Social Security, so his funds are limited. So that's why we're requesting a $5,000 bond on Mr. Holmesy's behalf, Judge.
All right, I'm ordering no victim contact until further order of the court, and Mr. Holmesy's bond will be $10,000. Deshaun McCrimmon?
Mr. McCrimmon, come on up.
All right, Mr. McCrimmon is before the court. Count one is carrying a concealed firearm. Count two is use or display of firearm during a felony. Count 3, possession with intent to sell, manufacture, or deliver heroin. Count 4, possession of cannabis 20 grams or less. Count 5 is possession of drug paraphernalia. And count 6 is aggravated battery on a pregnant victim.
Your Honor, the state is requesting a $5,000 bond on count 2, a $15,000 bond on count 6, no victim contact, pretrial release of the GPS monitor. In addition to these 2 new felony cases, Mr. McCrimmon is out on 2 other felony matters, one for introduction and contraband into a detention facility. He's also out on a second case for possession of cocaine, fentanyl, resisting without violence, no valid DL. In 2015, he pled out to possession of cannabis with intent to sell or distribute within 1,000 feet of a specified area, grand theft of a firearm, felony possession of a firearm, and delivery or possession of a firearm with serial numbers either modified or scratched off. 2016, possession of cannabis. Nothing further, Judge.
All right.
Judge, Mr. McCrimmon has been living in our community his whole entire life. He's 22 years old. Right now he is working. He works with his uncle doing landscape when weather permits. He makes approximately $90 per day. Now he'll be residing separate and apart from the alleged victim. He has family. He'll be residing with his grandmother in Pompano Beach. She is retired, Judge. That's who he's hoping that could help post his monetary bond. On count 1, Judge, we're asking for a $2,000 bond. And on count 6, we're asking for a $5,000 bond on Mr. McCrimmon's behalf, Judge.
And, Your Honor, as I'm sure the court, I know the court's aware Mr. Romero wouldn't be, he didn't see the probable cause affidavit. But according to Mr. McCrimmon's post-Miranda statement, he also makes supplemental income by other means.
All right, the court finds probable cause, 5,000 on count 2, 10,000 on count 6 with level 2 GPS, and no victim contact. Wilvins Matire,
He's approaching, Judge. He's here, man. Come on up, sir.
I'm leaving this one here because the TV's not in custody. They don't need it.
sir, you're before the court on a misdemeanor capious matter for possession of cannabis 20 grams or less. The court does find probable cause. What does Mr. Matire wish to do?
Judge, from what he informed me, this case, I believe, is at a drug court. He's looking forward to completing it, so this could be eventually dismissed. When I asked him why he missed court, he said it was a mistake. He was working. He didn't mean to miss it. I'm not asking for an outright ROR or pre-trial. I'm asking is, considering it's a cannabis offense, Judge, would the court consider reducing it to 1,000 as opposed to 2,000?
Your Honor, he missed court last November. I mean, what's been going on since then?
Yeah, he does have
He's been
court,
working.
he has court on the 30th, so, since he's in drug court, he can go to his division and have that conversation with his division judge, okay? Garvin Foster,
Yeah, we just.
Mr. Foster, come on up, please.
all right, Mr. Foster is before the court, resisting officer without violence, and count 2 is trespassing, and the court does find probable cause.
Judge, it's being Mr. Foster. He wishes to resolve this matter today.
One moment, Judge. Your Honor, if Mr. Foster wants to resolve the case, the state's offer would be an adjudication, 3 days in county jail. He was just arrested April 16th, just down the road on University for disorderly conduct and trespass. Looks like he pled that out to 3 days. He's had multiple priors within the past few years, and just also noting his response to, causing a disturbance at this store, and then his response when law enforcement arrived.
Judge, and speaking Mr. Foster, and considering what the state mentioned, Judge, he wishes to accept the state's offer as far as 3 days.
All right. I do know that Mr. Foster has been before this court a few times, and I am not accepting the offer at this time. His bond is $100, okay? I'm gonna resolve the case today. Little Hicks,
Judge, considering that the court's not accepting the offer, I asked Mr. Foster if he's in a position to post a $100 bond. He advised me, no, he is not. Would the court consider an ROR on Mr. Foster's behalf?
no, that'll be denied. Little Hicks,
Domestics are not in custody.
Come on up.
all right, Mr. Hicks is before the court for petty theft, and the court does find probable cause.
Judge, and speaking Mr. Hicks, he wishes to resolve this matter. I believe this is out of Publix. There's no outstanding restitution issues, so we're asking to resolve this case.
All right,
One moment, Judge. Your Honor, adjudication time served, no return.
okay.
Judge, he wishes to accept the offer.
All right, Mr. Hicks, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down, and please state your name for the record.
Little Marcus Hicks.
And Mr. Hicks, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
Ma'am.
And do you understand, sir, that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And sir, have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that would prevent you from making an intelligent decision?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
I'm a USA citizen.
Okay, and then what plea do you wish to enter, sir?
No contact.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir. Zachary Williams.
Correction, Judge.
All right, Mr. Williams, you are before the court for one count of petty theft, and the court does find probable cause.
Judge, speaking Mr. Williams, he wishes to resolve this matter today.
Okay,
Adjudication time served, no return, Judge.
all right.
He wishes to accept the state's offer.
All right, Mr. Williams, do you understand the offer?
Yes.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And Mr. Williams, is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Sir, you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today it could subject you to deportation or immigration changes.
Yes.
What plea do you wish to enter, sir?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. And then also, sir, no, what is this business? Is it,
Let's see, the last one. It's, Save a Lot.
okay, so no return to the Save-A-Lot. Do you understand that, sir?
Yes.
Okay, good luck. Joseph Charles.
Mr. Charles, come on up, sir.
All right, Mr. Charles is before the court on a misdemeanor capias for a trespassing charge. And the court does find probable cause.
Sure. And speaking of Mr. Charles, he's looking forward to having his day in court. I advised him why he missed court. He said he basically got a ride from his friend and they went to the wrong courthouse. He said he attempted to go back to the clerk's office to go ahead and have his court date rescheduled. Having said that, Judge, I'm going to be asking if the court would consider first an outright ROR on this trespass offense.
Does Mr. Charles have priors?
One moment, Your Honor. Yeah. Well, Your Honor, I'm checking, but this doesn't really make sense. I'm looking at Odyssey, and it appears that Mr. Charles didn't show up at a non-jury trial, and Judge Hurley issued a capias. There was a hearing in April to withdraw the capias, and Judge Hurley granted that. Then there was another non-jury trial set. It appears he didn't show up to that, and then this capias was issued. I don't know why he would say he went to the wrong court. He'd already appeared before Judge Hurley before and knew that's where his case was.
And is it correct that when the capias, when the capias was withdrawn, there was a $2,500? Oh, there was a $2,500 bond at the time that the first capias was issued. Is that correct? And then it was withdrawn?
I believe so, yes. Yes, the original, yes. Yes,
All
ma'am.
right. Okay, so, I'm gonna deny the ROR at this time.
Judge, then our second request would be this. When he was arrested, he just showed me his property slip. He got arrested and he had $50 on him. He wanted to self-bond, but unfortunately he didn't. And from what I've been informed with the deputy speaking earlier today, they already on your first day take $23 out. So I'm assuming he has about $27. So I'm asking the court to consider lowering it from $50 to $27 so he can self-bond.
No, I'm gonna put him on pretrial, supervision.
Pre-trial?
Yes.
Okay.
All right, so Mr. Charles, you need to report to the pretrial office on the information that has been handed to you. And if you don't report, sir, a warrant will be issued for your arrest. Do you understand that?
Yes.
Okay, sir, good luck. All right, Venetius de Almeida,
Bonded, Judge?
okay. Wayne Thompson,
He's here present at Maine, and he declined to serve as a public defender.
all right, Mr. Thompson, you are before the court for one count of DUI, and the court finds probable cause. I'll hear from the state.
I was,
I just want to go home back to Orlando. I was going to go move the trial to Orlando as well. I have like $100 pocket right now, I would like to use the bond myself out.
All right,
If you could
sir.
lower my bond, please.
Well, first of all, let me hear from the state. Second, this is not going to be, I mean, unless you have some good reason for the trial to be transferred to Orlando, that's not going to happen.
I live in Orlando. I
That,
go to school in Orlando. I work in Orlando.
Sir, those are not reasons to transfer a case that happened here in Broward County to another county, okay? Which is probably why you may need an attorney. State,
Your Honor, I was just gonna request that the bond be kept at $500, considering he does reside out of the area.
I would like that to be lowered. Have $100 in my pocket. I would like to bond myself out. I really got no family or friend in Fort Lauderdale to bond me out right now. That's the money I got in my pocket to get back home.
I do believe Mr. Thompson has means, Your Honor, considering he is, from what I can tell, the registered owner of the 2015 BMW that he was driving.
Which my mom bought for me for my graduation gift. I graduated from UCF last May with my bachelor's degree, and that was my gift.
all right, Mr. Thompson, your bond is $500, sir. Okay?
Can it be lowered?
No, sir, I'm denying that. $500. All right, Jonathan Sargent.
Mr. Sargent is approaching, Judge.
All right, I think I'm missing a page. I don't know, at least a page.
I think we all are then, Your Honor.
Oh, okay. All right.
One moment, Judge. Your Honor, I just asked that the matter be reset for 24 hours. I'll reach out to the arresting officer.
All right. Well, we'll reset for 24 hours, okay? Wesley Ramsdale.
How many do you have? Your Honor,
Yes.
I'm being advised by confinement might have all the pages.
Okay, hold on just a moment, sir. Mr. Sergeant, hold on. Why are you giving us false hope on this Tuesday morning? Sorry, Mr. Sergeant, we'll reset for tomorrow. All right, Wesley Ramsdale.
Yeah, my bond is $1,000.
All right, so Mr. Ramsdale is before the court. Count 1 is touch or strike battery. Count 2 is assault. Well, the court does find probable cause.
Judge, I'm going to be requesting a phone order.
All right. Does the state wish to be heard?
I wasn't going to be requesting any bond modification, just in order of no victim contact.
All right, so no victim contact, sir, and then your bond is $1,000.
Good luck, sir.
Eddie Rancher,
Medical research, Your Honor.
okay. Robert O'Brien,
Mr. O'Brien, come on up, please.
all right, Mr. O'Brien, you are before the court. Count 1 is possession of drug paraphernalia. Count 2, operating without a valid driver's license. Count 3, riding a motorcycle without eye protection. Count 4 is felony violation of probation, which has a no bond hold. Count 5 is a traffic capias, which has $1,000 bond, and then count 6 is the traffic capias on which you've been ROR'd. The court does find probable cause. And does anyone wish to be heard? All right,
Not at this time, Judge.
okay, so the standard bonds are in place, and he does have court before his felony division judge tomorrow at 8:30. Bakari Artis,
Medical reset.
okay. Tyza Brian
Mr. Artis,
Ross,
I believe is North Broward, Judge.
yeah, he's medical reset. Mr.
Oh,
Rawls
okay.
is next.
Mr. Rawls, come on up, please. Mr. Rawls, come on up, sir.
All right, Mr. Rawls is before the court. Count 1 is possession of heroin. Count 3 is attaching license plate not assigned. Count 2, that was 2. Count 3 is driving while license suspended. Count 4 is expired vehicle registration. Count 5 is felony violation of probation that has a no bond hold. The court does find probable cause. Mr. Rawls does have court before his division judge tomorrow at 8:30. Does anyone wish to be heard as to
No, Judge.
bond? Okay, so he has $1,000 on 1. Grenty Joseph,
Mr. Joseph, come on up.
all right, Mr. Joseph is before the court for burglary, unoccupied structure, unarmed.
Do you have anything for the next two?
The court does find probable cause. And I'll hear from the parties as to bond.
What? Your Honor, the state would request a $2,500 bond, no return. Based on the strength of the evidence, Mr. Joseph and his brother were essentially caught on the property in the act of committing the burglary.
Okay,
Judge, I'm going to be requesting Mr. Joseph be released on pretrial release. I understand this is his first time being arrested in his life. He's a registered voter. He attended Edison High School. He's 24 years old, been here his whole entire life. He's working right now. He has a great job. He doesn't want to risk losing it. He works at Amazon at the warehouse in Miami. He's been there for about 8 months, making $15 an hour. He lives with his mom. His mom's self-employed. I believe she cleans for a living. And from what he informed me, she's going through a financial crisis. So he doesn't know if his mom will be able to help post a monetary bond. And that's why we're asking for Mr. Joseph to be released on pretrial release.
all right, Mr. Joseph's bond will be $2,500, no return. Okay, Chilson Joseph,
Judge, he's here now, and I need time to speak to him. I haven't spoken to anyone past page 17.
okay.
Thank you, Judge.
All right, North Broward, do we have other persons that we can hear at North
I don't need all
Broward?
the details, just, okay, well, can you let me know when we go back to it? Here, let me-
All right, Paul Ryan Arconti, no one? So everyone else is at the main jail? All right, then, the court will be in a brief recess until they're ready.
this morning by his father. I know the family personally. It's my understanding he was picked up on not in custody, I think on an aggravated stalking.
Yes, hold on just a minute. Is Mr. Nader, Bert Nader?
He's right here. Come on up,
Okay.
Mr. Nader. He was just giving me the information of his private attorney and.
He's on page 21. Thank you. All right. So yes, Mr. Nader is before the court for aggravated stalking. And the court does find probable cause. And I'll hear from the parties as to bond.
Judge, I was going to ask for one of two things. It's my understanding Mr. Nader does not have any prior criminal history, at least as far as felony arrests go. So I was going to ask for a reasonable bond, somewhere in the amount of $1,500 to $500.
Please, Your Honor, please.
His father is prepared to post the bond. In the alternative, I think he would be a good candidate for pretrial release, being that this is his first felony offense. I'm really not familiar with the facts of the case other than a cursory review of the PC, but I believe it involves a victim that had previously filed for a restraining order. That restraining order was dismissed. She didn't show up to the hearing. So here we are. I think it involves the same set of facts.
Your Honor, the state is going to request a $15,000 bond, pretrial release of the GPS monitor, no victim contact. I would note this is a filed case. It has been investigated by the state.
Thank you.
There's included in the report before Your Honor, threats were made against the victim's children, including threats made against the victim and the other victim that did not wish to prosecute.
Judge, I don't know, unless we're reading something different, $15,000 seems a bit excessive in this case, especially in someone who has no prior criminal history. Based on my reading, Judge, this series of events took place over like a total of 5 minutes. Something that occurred at the residence of one of the victims. There was an argument with a boyfriend who was in the house.
Your Honor, someone allegedly tries to break in someone's door, and then later in the same day sends numerous voicemails, one of which says, "I know where you live, I know where your kids go to school." We are both reading the same report, and I think that type of threat warrants a bond that, on release conditions that the state is requesting.
All right, based on the allegations in the probable cause affidavit, I am going to impose a $10,000 bond with a GPS.
Thank you very much.
No victim contact, sir. That means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes, I do. Yes, I do.
All right. All right, good luck, sir.
Thank you. Thank you very much.
All right. Are we still catching up?
Hold on. Yes, Judge?
Are you still catching up or you need more time?
I'm about 3 more clients I need to speak to, but I'm ready on a couple more, Judge.
That's fine. So when you're ready, let me know.
Thank you, Judge.
Okay.
Thank you, Judge.
Okay, so let's proceed with Chilston Joseph.
Sure, he's approaching, Judge.
Are you gonna be hiring more on the public on the road?
All right, so Mr. Joseph is before the court for burglary on occupied structure unarmed, and the court does find probable cause. I'll hear from the parties.
Your Honor, he's had multiple previous arrests. I'm requesting the same bond that you set for his co-arrestee, $2,500, no return.
Okay,
And Judge, his financial situation is the same. He and his brother live with his mom. His mom is cleans for a living, from what his other brother advised me. She's going through a tough time financially, so we're going to be requesting pretrial on Mr. Joseph's behalf.
all right, so Mr. Joseph will have a $2,500 bond with a level 2 GPS, and no return. Okay, Jamarian Lee.
Mr. Lee, come on up, please.
Good morning, Mr. Lee. You are before the court for failing to stop or remain at an accident, and the court finds probable cause. I'll hear from the parties as to bond.
Your Honor, I'd be requesting a $3,500 bond. As you can see, Mr. Lee was involved in, one moment. And what the arresting officer notes was a serious accident where it appears that one of the passengers of the other vehicle involved in the accident has possibly suffered a broken leg. And Mr. Lee frankly just left the scene of the accident. He has a 2015 possession of PVP.
Okay.
Judge, we're going to be asking for the court to consider a little bit less of a bond, $1,000. He's going to rely on his girlfriend to help post his bond, and she does care for a living. And from what he informed me, he doesn't know if his girlfriend can even afford that, but is quite confident dollars. He's been here his whole entire life. He lives with his mom. His mom, right now, just recently got laid off from her own job, and he's looking for employment. So at this time, we're asking for a $1,000 bond on Mr. Lee's behalf.
All right, Mr. Lee's bond is going to be $3,500. Okay. Derek Rhodes.
Mr. Rose, come on up, please.
All right, Mr. Rhodes is before the court for grand theft. And the court does find probable cause. I'll hear from the parties as to bond.
I think pretrial has information for the court.
Okay.
Your Honor, Mr. Rhodes is currently on pretrial supervision in 2 cases. Case number 1-800-7878 CF10A, grand theft in the 3rd degree. And case number 190000531 CF10A, felony petty theft. At this time, we're going to request a revocation of his current supervision.
When was he placed on pretrial? And are those filed cases?
Yes, they are, Judge.
Okay.
Judge, we're going to be requesting a phone order.
Okay.
He was placed on pretrial supervision March 21st, 2019.
Both cases?
Yes, Your Honor.
All right, so. All right, so Mr. Rhodes, you have now, this is the 3rd theft charge that you're facing. These previous two charges, you were placed on pretrial supervision. March 21st was when you were placed on pretrial, and today you're before the court on an allegation of another grand theft charge. All right, so as to the new arrest, the bond is going to be $3,000. Case number 19-00531 CF10A. The charge is felony petty theft. I am going to grant pretrial's request to revoke pretrial. And your bond is going to be $3,000. And on case number 18-007-878 CF10A, the charge there is grand theft. I am granting pretrial's request to revoke pretrial, and your bond will be $3,000. Okay? Terrell Jenkins.
Hold on one second. Come on, Mr. Jenkins. He's approaching, Judge.
And, Your Honor,
Yes.
it looks like, I don't know where the error happened, but the officer's intent on count 2 was misdemeanor assault on a law enforcement officer.
Okay. All right, so Mr. Jenkins is before the court this morning. Count 1 is petty theft. Count 2 will make misdemeanor assault, just assault. Count 3 is battery on 3 and 4 are battery on an officer. Count 5 is resisting officer with violence. Count 6 is resisting officer without violence. Count 7 is a felony violation of probation with a no bond hold. Count 8 is a municipal ordinance violation. And count 9 is obstruction or depriving means of protection or communication. All right.
And Your Honor, based on the other charges, I have no objection to an ROR on count 2.
Okay.
I'd be requesting $2,000 bonds on counts 3, 4, 5, and, sorry, there's an additional count, I believe.
9.
Yes. What is it, or what? We haven't gotten to it yet. She hasn't said.
All right.
Judge, Mr. Jenkins is 37. He's been here his whole entire life. He works in landscaping. He's been doing that for about 1 year. When weather permits, he gets paid anywhere from $60 to $90. He lives with his sister in Fort Lauderdale, and his sister is the only person that can help him out financially. She works at a hospital in the cafeteria. So, Judge, I'm asking you to take that into consideration, determining reasonable release conditions for Mr. Jenkins. And I'm also going to ask you to sign a photo order so we can photograph the injuries of Mr. Jenkins.
All right. The court finds probable cause. Count one, $25. Count two, which is misdemeanor assault, he'll be ROR'd. Count three, 3 and 4, $2,000. 3, 4, and 5, $2,000 bond. And count 6 is $100. Count 7 is no bond. Count 8 is $25, and count 9 is $2,000. Okay? All right, Mr. Adeloju.
He's your man. Come on up, sir.
All right, sir, any more before the court for possession of LSD, and the court finds probable cause? We'll hear from the parties as to bond.
Judge, I'm going to be requesting a straight ROR on Mr. Adulojo's behalf. My understanding is this is his first time being arrested in his life. He's a registered voter here in Broward County. He's 24 years old. Attended Miramar High School class of 2012. So if the state can confirm, this is his first contact with the criminal justice system. I'm asking for a straight ROR. If not, I'm going to then the court to consider releasing him on pretrial release.
Yeah, no history, Judge.
All right, he'll be ROR'd on this count.
Thank you, Judge.
All right. And then Gino Rios.
Mr. Rios, come on up.
All right, Mr. Rios is before the court. Count one is reckless driving. Count two is driving while license suspended. And then counts 3, 4, and 5 are felony violation of probation with no bond holds and, you do have court tomorrow at 8:30 before your felony division judge. And you have $100 bond on count one. All right? Alonza Jones.
Mr. Jones, come on up, please. He's approaching, Judge. I know. Hold up. Yeah, flag it. He's down. He's here, present, Judge.
All right, so Mr. Jones is before the court for resisting with violence. Count two is trespassing. Count three is a misdemeanor KPS. The court does find probable cause.
Judge, Mr. Jones has advised me there's no one that's going to be able to pay his bond. He's been here since 1969, so we're asking an ROR on his behalf.
Your Honor, the state would request a $1,000 bond. Mr. Jones is already out on an ROR for battery on a law enforcement officer.
All right, count one, then it'll be $1,000, and he has a $1,000 bond on the KPS. Demetrius Warwick.
Mr. Warwick's here.
All right, Mr. Warwick is before the court. Count one is burglary, unoccupied structure unarmed, and count two is petty theft. All right, the court does find probable cause. And I'll hear as to bond.
Your Honor, I'm going to be requesting a $5,000 bond on count one. Excuse me, I believe pretrial has some cases. And Your Honor, just to advise the court, I know it's charged as a burglary structure. It appears as a burglary of a dwelling. One of the cases that Mr. Warwick is out on that pretrial has, it's a 2007 burglary of an occupied dwelling. Literally the same exact allegations. He went on to Miss Egan's porch and stole her cigarettes while she was home.
It's the same
literally this, if I hid the dates, you wouldn't know which one was which.
Okay. All right.
Judge, being Mr. Warwick, he's currently looking for employment. He's 23 years old, been here for about 2 years. He lives with his grandmother. Judge, he does not know his grandmother's financial situation, and that's the only person that can help him post any sort of monetary bond. So I'd ask for reasonable release conditions for Mr. Warwick.
I don't know. Is there something else going on here? Yes.
Your Honor, Mr. Work is currently on pretrial supervision in case number 17009069 CF10A. Burglary dwelling occupied in case number 17005999 CF10A. Possession of cocaine. He was released to pretrial supervision by Judge Ford on March 21st, 2019. At this time, we're going to request a revocation of his supervision.
Well, do we know if he was previously out on bonds? Because this is a 2017 case, and now he was only placed on pretrial this year.
The 2000, previously, he was placed on pretrial supervision back in 2017 with a $500 bond. Then he got placed back on supervision again on March 21st. For those two cases, ROR on all counts, so evidently something may have occurred. He was back in custody and released again to pretrial.
Your Honor, I'm just checking right now to see, yeah, it looks like there's been pretrial warrants signed before, just court ordered, detention orders signed before, on more than one occasion. I do see, yeah. It's just advising the court why he's, the circumstances that have, for his arrest, since these cases originated.
All right.
Okay.
Actually, I'm showing he was found competent March 20th. So it does appear that,
All right. As to the new arrest, I'm imposing a $3,500 bond. And I'm assuming that these two cases are before Judge Porth?
well, I don't know that they will anymore if he's
Oh,
been
that's
found
right.
incompetent.
That's right. Okay, so on case number 17009069 CF10A, I am going to revoke the pretrial supervision. His bond there is going to be $3,500. And as to 17005999 CF10A, I'm revoking his pretrial supervision, and he has a $3,500 bond on that charge as well.
Thank you, Your Honor.
Okay. Vincent Trapani. Okay.
I'm sorry, Judge, who did you call?
Trapani, is he
Oh, bonded, Judge, I apologize.
and Roderick Goddard?
Mr. Goddard, come on up, please. He's approaching.
Michelle, this predates you. Yeah.
All right, Mr. Goddard is before the court. Count one is possession of cannabis, 20 grams or less, and count two is distributing or delivering cocaine. All right, the court finds probable cause.
Judge, in count two, Mr. Goddard advised me he doesn't know anything about it. Can we find out when's the date of incident on count two?
August of 2018. Is it?
Judge, Mr. Goddard advised me he's out on pretrial on a case. Judge, he's 29 years old. He's been here his whole life. He gets disability. He gets approximately $60 per month. More importantly, this is what he wanted me to share with this court. He lives with his mom. His mom is also on disability, but she's going through a health crisis, and she is actually, I believe, scheduled for surgery.
Yeah, on her breast cancer. Breast cancer.
And
She
when is
just
that?
she just had surgery like 3 weeks ago, and she home and she don't got nobody there that like to help her.
I got you. So my bad. It's not that she's going to have surgery. She already had surgery. So Judge, we're asking if the court would consider releasing Mr. Goodard on pretrial release on count two.
Your Honor, he is on pretrial for a case in mental health court. That case involves charges of lewd and lascivious battery against a victim between the ages of 12 and 16 and sexual activity with certain minors. The state would be requesting that the court keep the bond that Judge Schiff set in place.
All right, so, the standard bonds are in place at $100 and $5,000, okay? Ian Burns.
Come on.
All right, Mr. Burns is before the court. Count one is battery on an officer. Count two is resisting with violence, resisting officer with violence. And the court finds probable cause. And here is the bond.
One moment, Judge. Excuse me. Your Honor, requesting a $2,000 bond on one, $1,000 bond on two. This is based on the allegations in the report. Additionally, Mr. Burns out of Broward has a resisting without violence, unlawful use of false name ID 2018, trespass 2018, shooting at or throwing a deadly missile 2017 with a VOP, 2-year state prison, disorderly conduct and trespass 2016, resistance without violence and threats to specified individuals 2017, theft 2016, resisting without violence 2016, resisting without violence 2016, battery, disorderly conduct 2015, stalking 2014, loitering and prowling 2014, burglary of a dwelling, theft 2012. Your Honor, it goes on from there.
Okay,
And Judge, Mr. Burns is asking the court to consider releasing him on pretrial release. He works in landscaping.
And I have a place lined up too.
Hold on one second.
Okay.
And he's working in landscaping. When there's work on a good day, he can make up to about $100. He lives in Coral Springs with his mother. And for what he advised me, his mother is retired and on a fixed income, so she can't afford to help post his bond. So Judge, that's why we're requesting pretrial release and a photo order so we can photograph Mr. Burns' injuries.
all right, I'll sign the photo order. Count one, he has a $2,000 bond. Count two, $1,000. Richard Laveau.
Mr. Lavelle, come on up, please.
All right, sir, you are before the court. Count one is burglary, occupied dwelling on arms. Count two is petty theft. Count three is possession of drug paraphernalia. Count three is resisting without violence. Count five is a no bond hold for a felony violation of probation. And you will be before your division judge tomorrow at 8:30. The court does find probable cause. I'll hear as to bond.
Your Honor, based on the allegations, considering this was his father's home, he forced his way into his father's home while he was present, and also noting he's on probation for burglary, I'd be requesting a $7,500 bond, no return, no contact.
Okay?
Judge, He's 20 years old, been here for 4 years now. He works when he can at a car wash. So my understanding when speaking to him, I guess it depends on the number of cars. But bottom line, his financial resources are quite limited, so I'd ask you to take that into consideration.
All right, count one, $5,000, no contact and no return to this location.
Let's see something.
Michael Lopez Perez,
Bonded, Judge?
Leon Young,
He's approaching, Judge.
all right, Mr. Young, you are before the court. Counts one and two are felony capuses with no bond hold, not for magistrate. Count three is a traffic capious, which has $1,000 bond attached to it. The court finds probable cause, and you will have court this week in both divisions. Okay?
Do you have anything on Manly?
Waverly Manley,
He's approaching, Judge, here at Maine.
all right, Mr. Manley is before the court for carrying a concealed firearm, and the court finds probable cause.
Nothing to add at this time, Judge.
All right, does the state wish to be heard?
No, Judge.
All right, $1,000 bond.
I'll call your mother soon as she gets.
All right, do we have Jesse McNair today?
I don't think so, but I'll check.
Still on loan?
I'll check. Oh.
All right,
Still,
Cedric, huh?
Still on loan.
Okay, thanks. Cedric Thomas?
Medical reset, Your Honor.
Mr. Thomas is a medical reset?
Yes, ma'am.
Thank you. And then, Kerry Hodge?
Oh,
Is
it's
Hodge a reset as
still on
well?
loan.
Still on loan?
Yes, ma'am.
And then Jordan Edwards?
He's here at Maine, Judge.
So you're talking, I don't even have the paper.
All right. So Mr. Edwards is before the court today,
What's all this?
distributing or delivering methamphetamines, count one. Count two is a violation of felony
I don't have it.
pretrial, which is a no bond hold and not for magistrate. Count three is a felony capious matter, which is a no bond hold and not for magistrate. The court does find probable cause. Does anyone wish to be heard as to count one?
Nothing from the state.
All right, so, Mr. Edwards has $1,000 bond on count one. Okay? And then Travis Bray,
Reset, Judge.
all right, and Mr. Bray is a reset. All right, I think that has gotten us through this Tuesday morning. I'll see everyone this afternoon.
Yes, ma'am. Thank you.